Welcome to the Illinois Divorce Guide podcast, where we break down the complex and emotional process of divorce into manageable, easy-to-understand steps. I'm your host, Greer Howard, and with me is Bobby Buchanan, widely recognized as one of Illinois' top divorce attorneys, offering unmatched insight and experience in family law. Welcome to the Illinois Divorce Guide podcast. We are here to break down the complex and emotional process of divorce into easy to understand and manageable steps. I am your host, Greer Howard, and today, as always, I am here with Bobby Buchanan, who is a top divorce attorney in Illinois, and he has some unmatched insight and experience in family law. So we're so grateful to be here with Bobby today. And whether you're just beginning your journey or maybe you're somewhere in the middle, there is so much to cover, and we want to offer guidance, clarity, and a little bit of compassion every step of the way. So we're excited to get started today on a new topic. So today we're going to be talking about what to expect when a divorce, it leads to court. So we know that most likely everyone wants to avoid litigation, but for some, going to court is the only way to settle some issues. So Bobby's going to guide us through all of the steps today, and from filing motions and gathering evidence, and to help us understand exactly what happens when you actually go to court. So Bobby, why don't we get started today by talking a little bit about maybe why someone ends up in court and maybe some situations that lead to litigation.
Greer, thank you so much again for hosting this and guiding this conversation. I'm excited to be here and talk through this process. Court is, I don't think it's something that any of us look forward to. And probably when we think about the divorce process, it's kind of the scariest part as far as the legal side. Obviously, stepping into the next chapter of our life and figuring that out outside of court is hard enough. But then you throw in this big, daunting idea of court that's really overwhelming. Can make us lose some sleep at night. So hopefully in this episode and this two-part, these two episodes that we're going to do, we can demystify some of it. So why would someone go to court, or how do we end up in court? Let's start there. Well, the first place that we end up when we decide we want to get a divorce is usually in a conversation with our spouse and trying to figure out some of these big issues. What's the schedule that we're going to have with our kids? How are we going to raise our kids together? What are we going to do with the house? What are we going to do with some other assets? If there's a business, how are we going to split the business? And for most of us, those conversations can go pretty well if we can control the emotional side of it. And that's ultimately where I see a lot of cases going from conversations over the dinner table, conversations with a mediator, into court, is that it gets very emotional. And why wouldn't it? We're talking about leaving someone that we once loved. Trust is broken, communication is broken, and it's hard sometimes. But that's really the crux of it. It gets too emotional, and we stop being able to make reasonable compromises and making good decisions as far as the negotiation process. It comes down to the emotion.
Yeah, I mean, divorce obviously is so emotional. I don't think anyone gets married, walks down that aisle thinking that they're going to get divorced. So it really can be such a crushing time. And, you mentioned that, okay, so if mediation and the negotiations fall short, here we are, we basically have arrived at going to court litigation, right? So what is maybe like the first step? I mean, is it filing for divorce? Is it actually filing, like making that action?
Yeah, good question, because there are a lot of different ways to start the divorce process. When we are talking about going to court, that's exactly what you said. It is the filing. And what we're actually filing is what's called a petition for dissolution of marriage. That's legalese for a request for divorce. And that's a 2 or 3 page document that your attorney puts together that tells the court, I'm married to this person. We've been married for this long. It keeps it very high level, generally speaking. And you file that. And by filing it, you get a case number, you get assigned a judge, and it opens up the opportunity to litigate your case. And we're going to go into really what litigate your case means. So that's step one. But that's not the entire thing. So like in order to complete step one, what we need to do is serve our spouse as well.
Ooh, okay. Well, that sounds really emotional. Talking about the emotion, circling back to that. So we're filing, but when you file, do typically with your clients, have they already had that conversation? People sort of know that it's coming, or are sometimes spouses surprised by being served?
Sometimes they are surprised, and there might be strategic reasons why it needs to be a surprise. But in most of our cases, the fact that our clients want to get a divorce is known to the other side. And there has become a point where it's clear that communications have broken down. And usually our clients have had to have some sort of conversation with the other side saying, if we can't do this and figure this out together, then I got to get my lawyer more involved. And so we then go ahead and file that petition for dissolution of marriage. And the next step is figuring out, okay, do we need to serve the other side? And basically what service is, and we've seen it in the movies before, you're getting handed documents and the person says, you've been served. I mean, that's really what it is. It's the same thing in real life, except they don't have to actually say you've been served. You have to hand you the documents. What you're doing by getting served is you then have a legal obligation to participate in the quote unquote lawsuit of divorce. So that's what service is, but it's avoidable. In most of our cases, we can file that petition and then we send a letter to the other side saying, we filed this in court. We don't want to embarrass you by having to serve you at home or at work. So we're asking you just file what's called your appearance in court so that you're participating. Don't force us to serve you. So again, we try to keep it as diplomatic as possible, even when we're filing the petition.
I appreciate you saying that, because it is good to know that you don't actually have to serve the papers, that there's ways around that too, because like you said, that could be kind of emotional or embarrassing. And in a way, it's almost like you're at the starting line and we've officially started. Both people are in this race. We have to engage at this point, right? Like we are getting divorced and you can't at that point ignore it, right?
Yeah. I mean, before you file, the problem becomes that your spouse doesn't really respect the process moving forward. They keep dragging it out. They say, well, I'm not ready. This has to be on both of our timelines. Well, it turns out their timeline is months or years down the road. And really, you don't want to wait that long. So by filing and getting them served or them filing into the case, deadlines start to happen. And the court will set initial deadlines. For example, they have to file what's called an answer within 30 days, or you both have to exchange financial affidavits within 30 days. And we'll talk more about the financial affidavit thing in a bit. But deadlines start to happen and they can't just ignore it. And if they do ignore it, the divorce is still going to happen. And it's going to happen even quicker if they ignore it at that point.
Wow. Well, once you file with the court, and obviously we've talked about this before, I mean, divorce can take some time, right? It's not something that, you file and we have this whole process ahead of us. And today we're specifically talking about litigation, which is an even longer process. So let's talk about some of the things where you might need some temporary relief. It could be potentially financial. Maybe you have children and you're trying to figure out, well, what is our time going to look like? How does some of that work once you filed?
Yeah, that's one of the biggest reasons that we do file for our clients, is because there's some sort of temporary issue that we need to resolve. Maybe because of the volatile environment in the house, somebody had to move out. For in this example, it's our client that moved out and there's 2 kids. And since they moved out, they've been really limited on seeing the kids. It seems like the other side is always busy, or they can't accommodate or compromise in their schedule at all. And they're making it really hard for our client to maintain the relationship with the children. At that point, it's really important that we go in and request that a temporary schedule be put in place. So we file what's called a motion to set a temporary parenting time schedule. And once that happens, the court usually in most counties will send the parties to mediation. And what happens is the judge says, in essence, listen, I don't want to get my opinions, my hands involved in your parenting before I have to. So before I do that, I want you two to go to a mediator and see if you can figure this out. And then they go to mediation, and the mediator says the same thing. Listen, you guys are way better off if you figure this out on your own rather than having the judge tell you what the schedule needs to be. So it creates some additional pressure on both sides to really start to communicate and try to figure it out together.
Yeah. Yeah. And you're such a proponent of communication, figuring this out, making your own decisions, coming together to negotiate and make a deal happen. We know it can't always happen, but you're so good about, trying to every last effort to make some agreements before you're actually having a judge make them for you. And I love that.
Yeah, absolutely. It's really the essence of co-parenting, which we've talked about a lot, is the more you two can figure these things out together, the better it's going to create a foundation for co-parenting going forward. If you have a judge figure it out, then it just doesn't feel like it's yours, and it doesn't have the same sticking power. So we always want to try to figure it out ourselves. Sometimes it's not possible, and we got to get the judge involved.
Yeah. Well, hopefully if they can come to that temporary agreement, they can be trying that out and maybe kind of figure out if that's going to work or not and how they want it to look in the future. So It's good. You get those temporary agreements down, and then all of a sudden there's a period that you call the discovery process. And this is a lot of gathering of evidence. So can you sort of talk us through what that part of the process is going to look like? Because it takes some work.
Yeah. Discovery can be one of the most tedious, time-consuming, expensive parts of litigation. And what discovery is, for the most part, discovery in most cases is like 75 to 90% financial. This is where we get all the financial details and evidence prepared as if we're going to go to trial. The place that we start is with financial affidavits. In Illinois, when you start a case, the first thing you have to do is exchange financial affidavits. And what a financial affidavit is basically a 10 or 11-page document that lays out in very specific detail your income and expense situation and your asset and debt situation. So you're going to list on there, how much money did you make this year? How much money did you make last year? What is your tax situation? What are your expenses, your major expenses and your minor expenses, mortgage, car, utilities? How much are you paying for groceries? I mean, it's very comprehensive. It's something that most of us would have to really sit down and spend some time doing. And then you list out your assets and your debts, your house, your car note, your mortgage. Those are the big things. Once you've done that, both sides exchange those financial affidavits, and that'll set the foundation for whether or not additional discovery is needed, or maybe you can settle the case just based on that additional financial affidavit.
Okay. So if you have the financial affidavit, but you mentioned that there's maybe some additional discovery. So what would some of the things be a part of that additional process?
Yeah. So with the financial affidavit, there's going to be a couple mandatory disclosures with that. You're going to experience your attorney asking you for your last 2 years of your tax returns, your most recent pay stub, maybe 6 months of bank statements. That will be included in the initial financial affidavit exchange. Once the other side gets that, they can ask for more documentation voluntarily. Maybe they want to see a copy of your car note or all your recent credit card statements, or they look at your bank statements and they see a couple charges that don't add up or make sense, and they want proof of those. So there's a period where there's some voluntary exchange. Now, you can either participate in that or you can not participate in that. And of course, this isn't legal advice for any individual that's listening or watching, but my general advice is just voluntarily exchange the information, because if you don't, then you're going to trigger that more formalized discovery process, which can be very tedious and laborious and expensive.
Yeah. So let's say that, someone's going through a divorce and we've talked about before, there may be some trust issues, or they are not, the other person is not being forthcoming, and they're not really giving all of the information, and the other spouse knows that they're holding back. What is that next process to sort of make them, how do you make someone, be transparent about, those sensitive topics?
Yeah, luckily, and this is why people go to court, because of the discovery tools. I mean, I often talk about the benefits and of different approaches, alternative approaches to divorce, like mediation or collaborative divorce, which you should absolutely look into and figure out whether or not it's right for you. But those methods, they break down if there's not transparency and trust in regards to the financial picture. So if you feel like your spouse is leaving something out or not being honest in their voluntary disclosures, then what we do is formal discovery. And that's where we send a couple basic documents. One is called interrogatories, and one is called request for production. Those are the big ones that we start with. And interrogatories is a list of about 30 questions that ask the other side to identify different financial, or identify what they may or may not have financially. So for example, it'll say, identify any real estate that you claim an interest into, which basically saying, tell me what you own as far as real estate. Identify any vehicles that you have. Identify all the debt you have. And they have to formally answer these questions and sign off on them and swear that it's true. So that's one thing. And then the other part of it is the request for production. That's kind of like the paper side of it, where you say, give me all of your bank statements for the last 2 years. Give me all your credit card statements for the last 2 years. And the other side has 30 days to accumulate all this information and put it together and turn it over. And you're going to have to do the same thing. And that's why this becomes a very tedious process. If you send out these formal requests for documentation, you can expect that request is going to come back to you as well.
Wow. So after you've gathered all of this information and you're sort of, processing the truth about, your financial situation and kind of laying it all out there, is this maybe another time to, consider going back to the table? Maybe once everyone has been transparent because they're forced legally to be transparent, is that a time where maybe people try to negotiate again before actually going to court?
It can be, definitely. And usually when we're representing clients through this process, we really try to go back to the settlement table before the whole discovery process has started, and even in the middle of it, in order to maybe short circuit all this work that's going to have to be done. I mean, discovery, depending on how complicated your situation is going to cost you, probably on the low end, about $5,000, and can go up to $50,000 if you have a complicated estate, if there's, maybe one or more businesses involved. It's just a lot of paperwork. So what we do is say, okay, maybe we have enough information now. Let's see if we can narrow the issues. Let's see if we have enough information, we can go back to the settlement table or go back to a mediator and continue the discussion. You can do that at any time in a case. You can settle a case at any time. You can go back to a mediator at any time if the other side agrees. If they don't, then you do have to continue with the legal process.
I was curious. You sort of mentioned that a lot of this discovery process is typically on the financial side. But I am curious, and how does it work in the state of Illinois? What if there's concerns about, for instance, like infidelity, or maybe there's drug use or alcohol abuse, or maybe some other factors that someone thinks would be important for the judge to know in their case, whether it affects the custody of the children or what certain things are going to look like in the future. Is that also a part of discovery or no?
Yeah, great question. It absolutely is. So if these issues you feel like are going to affect some legally relevant part of the case, most often custody, then you can add those into your request for production. So if there's certain documentation that you think would be relevant to proving that maybe there's some substance abuse issue, that can go into your request for production. Sometimes we get bank statements that show repeated large purchases at liquor stores, and it's like pretty much in plain sight what's going on. The other thing that we can do discovery wise that can unearth some of these issues and put them in the light of the court is what's called a deposition. And we've probably seen this a little bit on TV or maybe a YouTube clip of a celebrity doing one of these. And the deposition is basically giving testimony outside of court. So if we want to depose your spouse to really get to the bottom of some issues and understand what their sworn answers are going to be ahead of trial, we'll send them a notice of deposition and it'll say, you have to come to our office in 2 weeks at this specific time for a recorded deposition. And they come, we can have a video camera set up. Their lawyer is going to be there. We're going to be there. And we have the right to ask them questions for a few hours, actually, if we need to. And then based on those answers, that might lead to more requests for production or an investigation that we have that goes in a different route. Or maybe it'll expose something in the case that gives us leverage, meaning, we really exposed a weak side in this case. We can go back to the negotiation table and figure out how to use that to get this case over with. So depositions are very powerful.
Yeah, it's interesting you say that because, I wonder if with some scenarios, maybe if a ex-spouse thinks that, well, I'm not going to disclose this particular information, or they think they can hide something, and so they keep pushing to go to court. But do you see in your experience that when some of these things are brought to light that maybe aren't so great about, one spouse or the other, that they're more willing or motivated to try to want to settle because they know they're not going to look good in court based off some of those answers?
Yeah, absolutely. I mean, a lot of people, they don't realize how vulnerable court can really make you and how exposing it can be. So when they start going down this road, they see like, wow, this is like getting very personal. It's getting uncomfortable. It's very expensive. It's stressful. And that creates a pressure on both sides to maybe compromise in places where they weren't willing to before. On the other end, it can also have the opposite effect, which people need to know, which is like, it can make people even more upset at the whole process, even more emotional. And again, if that emotional temperature is running hot, finding a resolution and compromising can be even more difficult. So that's why litigation is so tricky, because it could have the effect you want, or it could kind of spiral and snowball into something that feels like, how are we going to stop this train? I'm going to just throw in as many metaphors as I can.
That's right. I mean, yeah, I guess it's true. On the other end, an ex-spouse could dig their heels in and say, okay, now that we're in it, I'm not going to negotiate. We are going to court, right? So maybe knowing their personality and whether that might be a good or bad thing could be, could come into play for this particular scenario, which is interesting.
And as I always tell people, and I think people know this as well, inherently, the only people that win when that is happening is the lawyers. And that's how, you can 6 figures of your estate can go easily away to the lawyers if you get caught up in litigation. It's not uncommon to have a case where both sides, if they get caught up in discovery and litigation, are spending $20,000, $30,000, $50,000 on attorney's fees. It's completely unnecessary and is only caused probably by two people who are emotional, maybe their egos are getting a little bit out of control, and they're not able to make some simple compromises that at the end of the day, 99% of cases settle. Whether they settle before discovery or after, they settle. So sometimes we get all the way to the finish line. We've prepared, we've done depositions, interrogatories, all this stuff. We're ready for trial. And then the case settles the day before trial because everyone's so exhausted. The writing's on the wall. And the judge says, listen, what are we doing, guys? We know all the issues here. Why aren't we settling this? And puts a final dose of pressure that gets it done. But it's a wild ride all the way to the end.
Yeah. Well, speaking of settling, so can you tell us a little bit about maybe just specifically, you've kind of touched on it, but the pretrial conferences, exactly like what that is, and then the court, or you've mentioned it, but also the court-ordered mediation. We've talked about mediation before, but maybe kind of talk about both of those.
Yeah, the pretrial conference is a pretty powerful tool to get a case to settle. And a lot of cases, they get litigated. They do settle shortly after a pretrial conference. What a pretrial conference is basically an informal settlement discussion with the judge included. So you're going to do your discovery. Both parties are going to get the case to a place where they feel like they have enough information. And pretrial conferences only work if both sides agree that there are maybe no factual questions, big factual questions that need to be answered. Like everyone kind of agrees what's going on in this situation, but they don't agree on what the result should be and what the legal result should be. So you ask the judge, you say, Judge, can we have a pretrial conference where we have, an hour, 2 hours of your time and we talk through these issues? And the judge will say, yeah, come back in a month or 2 months, whatever their schedule will allow. Between the time that you ask for it and you do it, you prepare for the pretrial conference by putting together a comprehensive memo that outlines all the major issues. You get the judge whatever other, exhibits or evidence you think might be relevant for the judge to review. There's some particular rules. The judge can't look at anything that they want. You go into that pretrial conference prepared because it is a very valuable opportunity to persuade the judge. And then the judge will weigh in and say, here are my recommendations for settlement. If this case were to go to trial, I'm going to do X, Y, and Z most likely. Or they might say, I don't know what I would do. It's a crapshoot. Does your client want to risk it? It could end up here. It could end up there. And it creates, tries to create an environment where people see that there's a clear incentive to settle. So we take that recommendation, we go back to the negotiation table, and hopefully at that point we can move the needle in order to get our clients to compromise and get this out of court and be done. So that's pretrial conferences.
Wow. Well, I tell you what, it's amazing how all throughout this process, if there is a theme, it is that at every step, when you're getting closer and closer to litigation, there's always another opportunity to try to settle.
Yeah.
And so it's so great to hear that because, if you're going through that divorce, you might want to realize that you're going to continue to get pressured to go ahead and settle. And the sooner you settle, probably the better.
Yeah, absolutely. And to talk about the other kind of tool or piece there that you mentioned before, which is the court-ordered mediation, that is another great opportunity for the whole thing to be paused, for maybe emotions to come down, and what a judge will do. And it happens most often on the custody side of things. If you do file that initial petition or motion for a temporary schedule, the court's going to send you to custody mediation. You can also do financial mediation. Mediation only works if you both agree to do mediation. If you're not, if one side is just opposed completely to mediation, it's not going to work. But if you have just a basic agreement, both sides are saying, yeah, I don't want to litigate this. I don't want to spend 5 figures of attorney's fees trying to figure out these issues. Let's go to mediation. Then you two will sit down. Sometimes it's with attorneys, sometimes it's not, and spend a few hours. Maybe it's a few days over the course of a few weeks, depending on how complex it is, but have that neutral mediator guide your conversation and help come up with a compromise. Judges are very supportive of people taking their issues out of court. So usually if you go to a judge and say, Judge, we think we can get this done in mediation. Can you give us a 60 or a 90-day continuance, meaning we don't have to come back to you next month, but we want 2 or 3 months to figure this out? The judge will say, yes, absolutely, good luck. And then you'll come back and report to the judge whether mediation worked.
Okay. All right. Well, we have covered a lot today, Bobby, and there's still more, honestly, to talk about litigation. So we're going to pause here because we're going to make a part 2. And part 2, we're going to get into attorneys for children. We'll get into bringing experts into the fold, also what it's going to be like to be in court in front of the judge and kind of that process. Is there anything else today that you want to either bring up that we haven't talked about or that you want to reiterate before we go?
I would just reiterate one, you have control on whether or not your case is litigated for a large part. If you can control your emotions, if you can control how you're communicating with the other side, really empower yourself to take control and take responsibility for your case and what happens. And the other side is things take a long time in court. So if your case does go to litigation, don't be surprised if, it's 30, 60, 90 days between court dates. Things aren't really happening as much as you want in court. It's not going to be this magic wand that just brings your case to an end. It's going to be the opposite. So really take control as much as you can over your case and take responsibility for your communication.
Yeah. Well, Bobby, thanks so much for all of your valuable insight today, as always. And we will continue the conversation on litigation in our part 2 next time. But we thank you so much for joining us today for the Illinois Divorce Guide podcast. We would love it if you would head over to our YouTube page, Illinois Divorce TV. Click that subscribe button. You can comment. You can share any of the videos that you think might be helpful for someone. And feel free to ask us questions. If there's a certain topic that you want us to discuss, we are here for you. That's why we have this podcast. We want to be talking about subjects that are interesting to you and that maybe you have questions about. So if you are looking to hire an attorney in Illinois, please reach out to Bobby and his team. You can go to their website, which is rbbfirm.com, or you can shoot them an email at info@rbbfirm.com. Well, thanks so much for being here with us today, and we will continue our conversation on litigation part 2 next time on the Illinois Divorce Guide podcast.
Thank you for listening to the Illinois Divorce Guide podcast. We hope today's episode gave you clarity and support as you move forward on your journey. If you found this episode helpful, please subscribe, rate, and review us on your favorite podcast platform. Tune in next week for more insights and expert advice on the Illinois Divorce Guide podcast.